I'm a question person, so good afternoon, and if you have questions along the way, I'm happy to answer them. I usually can keep going even if you interrupt me, so that's fine. If anybody feels the need to ask a question, ask away. And I am going to talk about the most exciting subject there is, I'm sure, for the day: ethics, conflict of interest, etc. Fernando gave you a really good primer on all the duties that are set out in the education code for regents. There's similar ones for trustees in the community college world. I'm going to try to touch on some of both. And so my first slide really kind of goes over a lot of the things that Fernando was talking to you, and this is not the exhaustive, this is just part of them. And I really want to talk about one in particular because I think it kind of overlays everything in terms of conflicts of interest and your ultimate duties to the institutions that you serve. And let me reiterate what Fernando and Kabi had said. What a fabulous thing it is that you all do. I know how busy everybody's lives are. I understand what a huge commitment this is. And when you sit here and listen to all the responsibilities that are now on your shoulders, it is really something special and something you should be proud of. Looking at the one that I really wanted to speak to is really the fiduciary duty. And you're like, what does that mean? You know, most people think, well, that really relates to money, isn't it? Isn't that just money? And even in the statute, it talks about funds, fiduciary for funds under the control of the institution. Well, that's interesting. But I will tell you that from a legal standpoint, and when you dig down into it, the fiduciary duty really overlays everything. It will define your conflicts of interest and your ethical duties to the institutions. Your fiduciary duty kind of breaks down even further. And you'll see a lot of this. For those of you who have served on public boards or are in public companies, you will have heard these kinds of things before. But your fiduciary duty is broken down into the duty of care, the duty of loyalty, the duty of obedience. What the heck does all that mean? Duty of care. So it means you need to make sure the information that you're using to make decisions is something that you should reasonably rely upon. It doesn't mean when you're acting as a trustee or as a regent that you are supposed to know each and everything about every aspect of the business that you are now responsible for. It is perfectly okay for you to rely on others for much of the information that you're receiving. So for example, you're talking about your endowment committee, you know, where your gifts and endowment is held, for those of you that have one, or maybe even your finance committee. And your treasurer, your CFO, your chief financial officer is going to tell you a bunch of information about how the money is held, what's going on in the market, you know, It does not mean you need to be an expert in everything having to do with financial markets. It means you need to make sure that that the institution has hired people that do understand those details. And they have experts and consultants that you should be able to reasonably rely upon. You can rely on expert advice in making your determinations. You can rely on information reports, statements presented by those one can reasonably rely upon. If it has to do with academic issues, you should be able to rely on your provost or your head of academic affairs. If it has to do with student issues, you should be able to rely on your head of student affairs and the like. If it's relating to legal issues, you're not supposed to be a legal issue expert in every aspect. That's why I would expect you to ask questions about, records retention or open meetings or, can we talk about this? That's what the institution has the experts for, and that is how you exercise your duty of care to make sure that the people that are in place actually understand the issues that are at hand. You have the duty of loyalty. Being loyal to the institution and not use the position of authority to obtain directly or indirectly a benefit for him or herself or for another organization in which the board member has an interest. So this gets me to conflicts of interest. The law changes on this, it seems, every legislative session. And I know in the past I have gone into the details about, what constitutes all the different levels of interest, like the levels of consanguinity and affinity, and your great-grandmother, does that count? Does your second cousin once removed count? This is one of those areas where I totally would tell you, use your duty of care and rely on somebody to answer those questions for you. If you and you really need to use, I hate saying this, your common sense. I mean, you don't act in your own self-interest, you act in the interest of your institutions. The law does differ between public institutions of higher education, state institutions, and ones organized under the local government code, community colleges. And the way the statutes require you to deal with those conflicts differs, but Fernando's correct. You disclose what that conflict would be. It can be in the minutes of the board meeting. Typically, I would ask for a conflict that is being disclosed in a board meeting to make sure that it is in the minutes. And you recuse yourself, and then the board acts without your input. Sometimes I will have, there are times when I would say it makes more sense after the regent or trustee recuses him or herself to step out of the board meeting so the board members can have a fuller discussion if it's on a matter of great importance and the person that is recusing themselves are particularly invested. That to me would be the most responsible thing to do. There's nothing in the law that requires that. But when you think about your duty of loyalty, you need to allow the remaining trustees to act in the best interest without your undue influence. So what would be included in evaluation of this duty? Could it be financial interests, political interests? Obviously financial interests, that's what everybody always is concerned about. Do you have an interest in the construction company? Does your brother-in-law own a construction company that your entity now wants to do business with, or something like that? Could be political interests. It could be even personal interests, examples, guys. Come on, wake up.
Examples?
Give me some examples.
Like real world?
Yeah. Like they want to know, where do these conflicts really come up? I mean, obviously, it's the financial ones that we see all the time. But there are others where board members may be involved. Fernando?
Well, board member may have a relative that is in desperate need of a job, or may have a relative that has certain interests that involve the university. Somebody that wants to do work with the university on a matter that would come before the board, or even if it didn't come before the board, it could still pose a problem. It could be that the board member himself or herself wants to, it's happened, they're told no and they accept it, that they have a business that they would like to do business with the board. And the proper remedy for that is And there are some exceptions that the state ethics code has put forward, but the remedy for that is you want to do business with the board, you resign, and then you can bid on the work. But those are some situations in which that comes up.
Anything else, Cotty?
I mean, the one I thought about was maybe not a business that you own, but a business your family owns. But that gets into the consanguinity and affinity stuff. But that's what the legislature was doing there, was trying to stop people from just putting the business in the name of their children or their wife or something like that and benefiting from it that way. One that could come up is if there is some sort of litigation in which the trustee is somehow, or regent is suing the rest of them. There could be a strong argument made that they shouldn't come into the closed session when you're going to discuss the case with the college's or university's lawyer, because they're in a conflict position.
Or there's a situation that where the regent absolutely disagrees with the policy direction that the board is wanting to take.
Correct.
And has some external interests, either somebody that they have in whose welfare they're interested, or in whose financial welfare they're interested in, and the board is going into executive session to discuss, a potential contract. That regent should never be in that executive session, much less the open session, much less the closed session. One situation that arose years ago was the termination of a president, where the regent was absolutely the only one on the board that wanted to retain this individual, and did everything he or she could externally. It's what I was talking about a while ago, externally, to put pressure on that board to retain the president. Now, that regent should not be in on those deliberations, certainly not in closed session, or just in general. If you're if you're a loyalty to somebody else or to some other entity, you're going to have to dispose of that before you shouldn't take your seat at the board table. Donna's absolutely right on that.
Yeah.
And not only recuse yourself, but leave the room, and she's right on that too.
So we've talked a little bit about duty of care, duty of loyalty, duty of obedience. That's my next one. I like this one. Ensure the college is or university is operating in furtherance of its stated purposes, bylaws, strategic plan, and operating in compliance with the law. The duty of obedience is really always just to do the right thing, following the law, making sure that there is somebody paying attention to compliance in your institutions, and that's something that's taken seriously. I think your relationship you have with your internal auditor is key when you're looking at your duty of obedience and compliance with the law and the rules and the policies of your institution. It's something that each board should know and have confidence in that internal auditor or chief audit executive, whatever the title you might use, is that is a key relationship and is often one of the two individuals, the president or chancellor, as well as your chief audit executive, should typically report directly to the board. Your chief audit executive should be the one to help you make sure your duty of obedience is maintained.
Yeah.
We'll go back again to the corporate best practices that are applicable to higher education, and these all kind of flow out from the fiduciary duty, duty of care, duty of loyalty. Ensuring there are clearly defined roles, responsibilities, and accountabilities. Practicing and holding good ethics, keeping integrity in high regard. That's your duty of obedience, among other things. Ensuring strategic management, aligning goals with the mission. Creating organizational effectiveness and governance, providing effective risk management oversight. Wow. Creating organizational effectiveness. Risk management, part of your duty of care. So what does that mean, organizational effectiveness? You're going to hear this in your roles as regents and trustees, the whole concept of shared governance. Like, how does that, now that also is part of, all, as I say, it all flows out of this fiduciary duty. You've got organizational effectiveness and shared governance. We're kind of a unique entity. It's kind of like bureaucracy squared, or more than that even. Sometimes it's phenomenal how hard it is to make a change in policy or direction for an institution because we are part of the shared governance process. Really, that just means to make sure there is transparency. You've heard that word from our group here today. And there is an opportunity for others to share their input. It doesn't mean, shared governance is not the same thing as faculty governance. Sometimes the faculty like to confuse that. It is important to get their input, but the ultimate responsibility, goes up. The president needs to be comfortable with those policies that if they're board policies, the board's going to have to be comfortable with them. It doesn't mean that the faculty are going to be making those decisions for you, but it is all part of the process and is something that is essential for your exercising your duties. Best practices. Okay, here, like, how do we do shared governance as it relates to the board? Engage with your faculty. It doesn't mean board members go out and talk to individual faculty members. And we're going to talk a little bit about that later on when we have some examples. But it does mean that you hear from time to time from your faculty Senate president, for example, or sometimes it may be that there are going to be presentations at your board meetings from faculty, so you have an idea of the issues that are of concern for the faculty. It could be through your academic affairs. But it's something that in the higher education context is essential and something that you should have some understanding of and is really part of the best practices. Risk management, this is really the twofold, making sure that there's somebody's paying attention to the risk, understanding how much tolerance there is for risk, never going over the edge, as my chancellor likes to say, like, Donna, you can take me up to the edge, but do not ever let me go over. And I totally appreciate and expect that. It is our job as lawyers to really make sure, as I sit there through every board meeting, I'm always thinking about our board policies, our board bylaws, the education code, the history before, the previous board meetings, the previous administration. You've got to have somebody that's thinking ahead and backwards. I like to think, way back and then 10 steps ahead to make sure that what the board is doing isn't going to cross over something that they've done before or something that I know that they're going to be doing in the future. That's part of, to me, the whole risk analysis and making sure that we don't step on toes. Prioritizing and monitoring risk, monitoring your plan through reporting to the board. These, to me, are all key aspects of board responsibility. Duty of loyalty, practice and holding good ethics and keeping integrity in high regard. That's like a non-negotiable. That's something that is something I would expect you all to look to your internal auditor, your general counsel, all your senior management staff, and know that they understand where their board is coming from with regard to integrity. You hear the adage over the years. I cannot tell you how important it is. Having the tone from the top of doing the right thing at the right times is essential, because it will be conveyed down below. You would be amazed how many people actually believe it or not, listen to these live streamed board meetings. You'd think who in the world would ever want to watch that, but I will tell you that there are staff across campuses that really are listening and hearing every word you say. You think it's just, sometimes a 8-hour boring meeting in some regards, but I'm telling you the staff really do pay attention, and the words that you use do matter, and the tone from the top in terms of integrity and doing the right thing and following the rules makes a huge difference. Faithfully pursuing the interests of the institution and its charitable or public purposes rather than one's own interests or the interests of another person or organization. Kind of the examples we were speaking to earlier. Disclosing your conflicts of interest, maintaining confidentiality, retaining the board's independence from external and internal stakeholders in the conduct of its oversight and policy responsibilities. Sometimes a board has to do things that are unpopular publicly, but your duty of loyalty, your duty is always to the institution itself. For those of you who are lawyers, or you will have heard lawyers say many times over the years, who's your client? Who's your client? And I always explain to folks at the university, the institution is my client. It's really a very difficult concept to explain and really to understand, because the institution itself is a thing, but it's really made up of people. So are those people my clients? Really not. And I know that's a really hard, you look to your lawyer, and I know I've got my regents sitting here, I'm looking at them, and they're going to say, are you my lawyer? Yes, I am the lawyer. I'm the lawyer for the institution. I'm not their personal lawyers. I'm going to look out for the best interests of the institution. And for their role as a regent, I am their lawyer, but I'm not their lawyer. And so you all have anything to add? I mean, it's a very difficult concept that I think is essential for understanding how important your duty of loyalty is and how it's effectuated as a board member.
Well, you're right. You're a lawyer for the institution, but the board only can act, as Kavi said, and has been said earlier, can only act as a body corporate. That's it. And as a body corporate, you are the institution. You are the University of Houston. You are Texas State University. You are UT. You are Austin Community College. As a body corporate. Now, there are times when you may be sued in your official capacity, or perhaps even in your individual capacity. As a regent or trustee, you will be entitled to representation in that capacity also. Mm-hmm. And in that capacity, then Donna can say, yes, I am your lawyer.
Correct.
Or the Attorney General's office if you're if you're a university. I am your lawyer in your individual capacity. Now, if you're sued in your individual capacity, you can obviously hire your own lawyer, but the attorney-client relationship adheres primarily between the attorney and the board. Now, having said that, I work for a chancellor. I don't work for a board. But I understand that if there's a conflict, as there was, I'll share something. I probably shouldn't be sharing this with you, but
Then don't.
I will share it with you anyway, because it was public. But there was a time years ago when the board wanted to part with its chancellor, and in that situation, he had the knowledge and the experience to understand that, and he came to me and he said, I understand that you will be attorney for the board.
That's right.
And he recognized that Because when it all falls out and you sit in these positions, if you do not want to represent that board, what the board's going to do to protect the institution and protect itself, you're either going to look to your counsel. If your counsel's loyalty is to the executive or elsewhere, where are you going to go? You're going to go to outside counsel. Whether it's to the AG's office or to go hire outside counsel, or you're going to go to outside counsel, because you're adverse to your chancellor. But you are the institution. You are the owners of the property of the institution. You have power of eminent domain, many of you, and I guess in
Yep.
community college.
Yeah.
You are the government as a body, not as an individual.
Correct.
Yeah, I'll just add to that. It's a hard concept. I mean, I've actually done CLE trainings on this and done trainings for like city attorneys and things like that to help people understand that the institution is the client. You can make the case that if you have a 9-member board, then 5 of you are the client. Whatever 5 of you agree on is what the client wants. But the duty of the attorney actually runs deeper than what the 5 of you want. If what the 5 of you want to do is illegal, I don't have a duty to carry that out, and I actually have a duty to try to stop you. And under the rules of ethics in Texas, I can actually go to an outside enforcement agency and say they're trying to break the law. Because the duty is to the institution and the integrity of the institution, and not to the individual people who populate it. They're the ones who make decisions. They're the ones who we deal with. But ultimately, if your interests and the institution's interests have gotten so diverse or adverse that you're trying to perpetuate a legal violation or take some action that is so tenuous that it's going to cause massive damage to the institution, the lawyer's duty is to that body and to the institution, not necessarily to what the 5 of you or 4 of you say you want to do.
I guess the bottom
It's
line-
complicated.
I guess the bottom line for me is that the only meaningful legal decision sitting on a board, such as the ones you sit on, that you will ever make or have to make will be made jointly.
Correct.
Yep.
There is no other decision you can make that would be legally binding as an individual or as a group less than a quorum at a publicly posted meeting. You are the institution. That's why Donna talks about how awesome the responsibility is.
I want to get to our hypotheticals, so I'm going to skip through some of these slides. I think you all will have them. Enjoy reading them, I'm sure. But if you had any questions, you certainly could call and ask me. I'm happy to respond to any emails that you have or phone calls. So I'm going to kind of the Ethics Commission is this should nots that I have here is really about gifts and all the things kind of we've gone over about conflicts of interest, and duty of loyalty is different in terms of contracting what you need to do for a community college than what you do for a state entity. But let's get to some of these hypotheticals. Here we go. Because this is kind of where the rubber meets the road, because these are things that will happen to you in your roles. President, Chancellor of your institution invites you to attend a basketball game to meet with potential donors for the athletics program. What does that have to do with your role as a regent? What's your role there? Anybody? Represent.
Development fundraising.
Yes. Obviously, you have the issue of who's responsible ultimately for the fundraising. There's always the issue. Your role is to represent the institution, to present the institution's interests, but you don't make the deal as it relates to whether we're going to accept X, Y, or Z gift for X, Y, or Z reason.
No, all I'm saying is I know that's the job of the development officer or
Yes.
the foundation, but in a lot of situations like that, they just want us to be there as show support for representing the college.
Correct.
The role of a regent is to represent the college to the community and the community to the college. So
Correct. Your brother owns a consulting company that's planning on placing a bid for a major contract. You come to find out that his company was selected as the vendor, and the contract for this project comes to the board for approval. So what do you do? What do you think?
Abstain?
Pardon me?
Abstain?
Abstain, recuse yourself, disclose, recuse, step out, don't vote on the contract. If on the community college side, there's forms that you have to fill out to disclose that relationship. On the state institution side, it is really disclose, recuse, and don't be involved in the vote. I like this one. You get a call from the governor's office insisting that you vote against any tuition increase because the governor is concerned that it will hurt his reelection bid. What do you do here? I know this couldn't happen. I know that. But this is just a hypothetical. But let's just pretend it could happen. What do you think you do with this information? You get the call from somebody in the governor's office. What do you do? Anybody? Okay, Cobby, answer the question.
I'll say if we turn the cameras off, will people answer? I think you have to listen politely and ultimately make your own decision about what's right for the institution when you vote.
Right.
There may be consequences afterwards, but you've got to do what's right for the institution.
Right. Your loyalty is to the institution. The dean of the School of Business sends a letter to the board where he has made the decision to raise the annual teaching load of faculty members based on the amount of publications. This new requirement was applied retroactively to past performance. The dean hasn't discussed this with any faculty members, but wants the board's input. What do you do? Okay, you can say this on camera. It's okay. What do you do with this one? That's right. It is not a board responsibility. This is the responsibility of, if the dean comes to you, first the dean shouldn't be coming to you.
Yeah, you got to redirect them.
You redirect them to the provost. You might disclose this to your president. Your president will talk to the provost or the chief academic officer and say, we got to rein in our dean because this is not the role of the board to be involved in something like this. It's really something that shouldn't come to the board.
Getting involved in this kind of stuff, too, can have implications for accreditation under the SAC standards. They've got very definite ideas about governance and the roles of the board versus the role of the administration and management. And they will write you up and they will put you on probation, and ultimately they can take your certificate away, your
Correct.
certification away.
And they do, and I will tell you, SACS does pay attention to what goes on in those board meetings. They absolutely do.
Yeah.
And we just went through accreditation. I know they look at those things. You are approached by a friend who intends to bid on a new construction project on your campus. So no relationship, just somebody you know. He asks if you could give him some tips to make his bid more attractive. He also asks if you could put him in contact with someone in your construction group. What do you do here? What's your best response? Anybody? What do you think? Okay. All right. So, this is something that absolutely will happen to you. I guarantee you it's going to happen to you. If you think it won't, I just can't even imagine that it wouldn't. I know it will. I've heard the question come up too many times. Mm-hmm. Your role is really to tell your friend, I can give you the number for the head of administration and finance or your CFO, and they can, here's the phone number to the procurement office. They can tell you how that process works. But no, you can't get involved in how am I going to make the bid more attractive. That's not your role. That's not, that is certainly stepping out of your role and thinking not in the best interests of the institution.
And if you have a blackout period, it may be a violation for that person to even talk to you.
Correct. Disclose it to your.
Yeah, definitely disclose it.
Disclose it.
Yeah.
You're informed in executive session, your president, chancellor has approved multiple emergency leaves for up to 4 months for several departing employees. You're also told this is appropriate, but you're aware that there are multiple media reports questioning the legality of this approach. What do you think you do with this one? So on this, what I would recommend is you're going to ask your general counsel, like, is this legal or not? I mean, I would want to confirm, is this okay or not okay?
Yeah.
There actually are state statutes that define leave, and this is not something that should be done just indiscriminately. So from a legal standpoint, I would question the legality of something like this, but I would lean on your legal officer, or maybe your human resource officer, or the president, someone like that. I would go back and make sure that the real issues are being answered. If you feel like you're not getting a straight answer, that's why you have internal audit that reports directly to you, that should be giving you the correct answer.
Real quickly, that was a very hot potato just a couple of years ago, and indeed there's a governor's executive order on emergency leave in addition to the statutes. So by all means, be in touch with your general counsel on that issue.
So that's my last slide, but I do have one more hypothetical that I just want to throw out, just because I know this is the one that happens probably more than any other that you will have. And that's where you get a friend that's asking you to intervene on behalf of, let's say, their daughter who's seeking admission to the institution. What do you think you're supposed to do in those situations? Any ideas? I'm sure this has never happened to anybody here. Not one time, I'm sure. Never once. Okay, good. I'm really glad that it hasn't. But let me just say, hypothetically, if it were to happen, you shouldn't use your role in a way that would give the appearance of private gain for others. You can never separate yourself from your role as a regent. So really, I would turn it over to the president. Some would even say it's not even a good idea for a board member to write a letter of recommendation. I would say that if you have a personal relationship with that potential student, I actually think that's okay. I know we have had these discussions over the years. We don't always agree. I do think that it's okay if you have a personal relationship.
Well, you're right. An argument can be made that because if you look at the gifts law and how those work, you can accept a gift from somebody with whom you have an independent personal relationship. And so along those lines, I think what you say in the letter is, I've known this person all of my life, or I've known her parents. I know her to be of good moral character. I know that you will apply your policies in an appropriate way, but I want to speak to her character or his character, or whatever his qualifications, and for your consideration only.
And act
and
as
your
you
decision.
would, and for your decision, because
Your decision only.
part of the concern when a board member writes these letters is the fear of retribution from the staff, on the staff's part, when they get such a letter. Like, I'm, so-and-so admissions person, this is my job, and I've now got this letter from a board member. That's pretty impressive to them, I'll be honest. And so you have to make sure that it's clear when you write these letters or you present a student that you know that you tell them they need to act based on what's best for the institution, based on the standards of the institution.
I'll say that most community colleges don't have a lot of difficulty with admitting people. So it doesn't come up much in that context. It does come up sometimes in terms of people who are applying for jobs.
Yes, same thing, yes.
And the thing I would advise you is just look to see if you have like a code of ethics that's been adopted by the board for itself. Sometimes they have provisions in there that say things like you will not try to influence any decision of the administration or operation of the college. Someone could make an argument that if you're giving a job reference on behalf of somebody, you could be violating that, so you might want to just check to see how we interpret it. I think what Fernando and Donna have said is, if it's a personal relationship, it's probably not a violation of that, but you might want to make sure that's how your institution views it. So you don't want to step into something accidentally. Oh, we done?